We're back on the air. This is Radio Entrepreneurs. My name is Jeffrey Davis again, and again, heard across the World Wide Web. Please continue to join our ever-increasing network on YouTube and on Facebook and LinkedIn. We like knowing you're out there. We like supplying you with the data, our thought leadership data. Our next guest, not really a guest, is our litigation and business reporter, Mark Furman from the law firm of Tarlow, Breed, Hart, and Rodgers.
Jeffrey, great to be with you.
Thank you, Mark. Great to have you back again. What's the topic du jour?
Employment discrimination. Business owners have so many things to worry about, so many decisions to make, but one of the areas that's so complicated are the employment laws, and we wanted to talk about a discrimination case decided by the Supreme Court in the last week or so. You know, this time of the year I like to talk about Supreme Court decisions that are relevant to business owners, and here's a pregnancy discrimination case involving UPS, United Parcel Service.
Yes.
A former employer of mine when I was in college and doing
You had a brown jacket?
and doing Christmas season work while in college. But in any event, they had a part-time employee who became pregnant around 2006 or so, and her doctor said she could only lift a very small amount of weight. And UPS had a policy that required, she was a part-time driver, UPS had a policy that required part-time drivers to lift 70 pounds. And you know, a lot of these packages that get shipped are quite heavy. So it was a uniform policy, UPS said. She asked for reasonable accommodations based upon the fact that the Pregnancy Discrimination Act talked about treating pregnancy folks who were pregnant similar to other employees.
So she's on the truck schlepping and she's pregnant.
So because of her doctor's limitation on lifting, UPS said she can't work. So she was, no other job was offered to her, so she didn't work throughout the pregnancy and then returned to work a few months after she gave birth. So she filed a federal claim asserting that they had discriminated against her. And the district court found that she had not been discriminated against. The Fourth Circuit Court of Appeals affirmed, and the United States Supreme Court by a vote of 6-3 reversed. And the case was not decided on purely conservative liberal lines, as some cases are. You had Chief Justice Roberts and Judge Alito in the majority. So what had happened was, we've talked about summary judgment in the past. This is a procedure where at the end of discovery the defendant can seek to have a claim thrown out of court on the basis of there's no evidence from which the plaintiff can win the case. No need for a trial. Defendants love to try to get cases thrown out on summary judgment because there's always the risk if you go to trial. So here UPS had moved for summary judgment, got it in the district court, affirmed by the Court of Appeals, but the Supreme Court has sent it back for further proceedings.